Offensive content is any content that had been broadcast or published that likely to turn into upsetting, insulting, or unacceptable to some or other people. For instance, a sexually suggestive joke, prejudice in judging others based on their race, skin color, religions, or political belief. Offensive content can bring lots of damages toward the victim, such as depression, physical health, damaging their reputations and others. Because of the situation, Malaysia has amended Communications and Multimedia Act 1998 to regulate the telecommunications and multimedia industry. Section 211 and 233 of CMA1998 are the main section that enable the victim to take legal actions against the offenders.
Hello, my name is Emily Sawon and I'm going to present on Malaysian law, Section 211 of the Communications and Multimedia Act 1998. Nowadays, the society, especially the online users, always like to spread unverified and false news or rumors. Thus, Sections 211 subsections 1 provides no content application service provider or other person using a content application service shall provide content which is indecent, obscene, false, menacing, or offensive in character with intent to annoy, abuse, threaten, or harass any person. These sections was provided in order to protect anyone from being a victim to any forms of abuse or cyberbullying on the internet. Meanwhile, subsections 2 provides a person who contravenes subsections 1 commits an offence and shall, on conviction, be liable to a fine not exceeding 50,000 ringgit or to imprisonment for a term not exceeding 1 year or to both, and shall also be liable to a further fine of 1,000 ringgit for every day or part of a day during which the offence is continued after the convictions. These subsections explain that any person who did not comply with subsection 1 will be fined up to 50,000 or jailed up to 1 year or both. He or she may also be further fined up to 1,000 for every day or part of a day if the offence is still continued, even after convictions. For further understanding, let's look into the following cases.
Assalamualaikum and hi, my name is Ayman bin Rosli, number metric 264746. Today I'm going to make a presentation for cases under Section 211 of the Communications and Multimedia Act 1998. There are 5 categories of offensive contents set out under Section 211 of the CMA 1998, namely indecent content, obscene content, false content, menacing content, and offensive in character. However, the Act does not provide for the meaning of obscene. The meaning of obscene can be found in the case of public prosecutor against Shazan Amir bin Endor, whereby in this case the offender has been charged under Section 233 subsection 1 paragraph A of the Act for consciously created and initiated the transmission of obscene content with intent to offend others. In this case, the offender used the MMS application service to send obscene content to the victim, in which it is a picture of the victim's wife having an intimate relationship with the offender. This has caused the victim to feel hurt and embarrassed. In this case, the court considered the MMS image as being the obscene content. Now my friends will continue with another case. Thank you.
Next is offensive in character. This can be seen in case of Muhammad Fahmi Reza Muhammad Zarin, again public prosecutor, is charged under Section 2331A of the Communication and Multimedia Act 1988. His error using the application service through his Facebook profile page and sending false communication with intent to offend. The defendant fabricated the MC's warning notice to criticize the government and authorities. The notice, in which he claimed to be a parody, lies a clown-faced caricature of one of the political figures in Malaysia. Parody means emulating the style, design, and appearance of another work by altering an element from the original or adding an element of the original with an injection of humor and intended to convey a message. The appellant claimed to only criticize the action of the authorities in restricting the people's freedom of expression, in which he believed was wrong. The communication made by the appellant is offensive in character and false. The court upholds the principle on which it takes the view that it is not about whether the other party felt offended by the action, but whether the appellant has the intention to offend others. In this case, the appellant has the intention to offend the others, and hence it fulfills all elements under Section 211 of
Hi, I'm Mila. I'm going to explain about Section 233 of the Communication and Multimedia Act 1998. The section explains that any person who uses any network facilities, network services, and so on to produce or create the transference of any commands requests that is obscene, false, or offensive with the intention to annoy is said to be committed an offense. Furthermore, any person who commences a communication using any application services continuously, repeatedly, or otherwise, even though the communication may or may not occur with or without revealing his identity, with intention to annoy, abuse, threaten, is said to commit an offense. Subsection 2A and B elaborated that any person who purposely uses a network service or application service to allow any obscene communication for business purposes to someone or authorize a network service or application service under his power to be used for an activity that being set out in paragraph A is said to be committed an offense. Subsection 3 of this section provided the punishment, which interprets that any person who commits an offense under this section will be fined up to 50,000 ringgit or jailed up to 1 year or both. He or she may also be further fined up to 1,000 ringgit for every day or part of a day if the offence is still continued even after the conviction. Section 233 promotes maturity, responsibilities, and accountabilities for online users in order for them to check their posting before publishing on the internet. Now, let us have a look on the cases.
This is topic 5, case relating to Section 233 of Communications and Multimedia Act 1998. One of the cases is Rutini bin Suhaiman v. Public Prosecutor. He was sentenced to 8 months imprisonment in addition to a 15,000 ringgit fine. By the end of the prosecution's case, the first trial judge released and acquitted the appellant. The prosecution successfully appealed to the High Court. Therefore, requested that the second trial judge dismiss his defense on the grounds of the doubt in the appellant's and his witnesses' testimonies. The court held that there was barely any consideration by the trial judge of the possible defense in acquitting the appellant, based on the unquestionable fact that the appellant's computer and internet account were accessible by third parties. Therefore, there was no clear proof that the appellant had actually made and initiated the transmission of the dispute entry.
The reason for the holding is that the second trial judge clearly took the wrong approach. The possible defense was scarcely considered on the basis of the undisputed evidence that the appellant's computer and internet account are open to third parties. It would appear more in the minds of the second trial judge that the appellant must have made the impugned entry because he failed to prove that it was done by another person. The second trial judge had misdirected herself in law in taking the erroneous method and refusing to recognize the appellant's possible defense. The appellant's defense was severely prejudiced by the second trial judge's erroneous method. 233 subsection 1 clause A1 and clause B2 of the Communications and Multimedia Act 1998 state the providing. Section 233 subsection 1 clause B is included because although the appellant's preferred charge was pursuant to section 233 subsection 1 clause B, the learned judge of the High Court remarked his decision under clause B. The key component in this crime is that the accused person made the communication in question through a network facility and the contract was with intent to annoy, abuse, threaten, or harass any person.
There is a thin line between expression and hate. Free speech is the freedom to unrestrictedly express our thoughts and opinions. Article 10 of the Malaysian Federal Constitution states that every person has the right to freedom of speech and expression. However, this can be limited by Clause 2, 3 and 4 of the same article. On the other hand, hate speech is the abuse of that freedom to harm someone or expression intended to cause violence. There are 2 UN conventions which contains provisions related to hate speech, which Malaysia has yet to ratify. The first one is International Covenant on Civil and Political Rights. Article 20, Clause 2 states that any advocacy of national, racial or religious hatred which constitutes incitement to discrimination, hostility or violence is prohibited by law. Secondly is the Convention on the Elimination of All Forms of Racial Discrimination. Article 4A states that the propagation of ideas based on racial superiority or racism, incitement to racial discrimination, and the act of violence or incitement to such actions against any race or group of persons of other color or ethnic origin shall constitute an offence punishable by law.
Freedom of expression is not absolute. It is clear that freedom of expression is not absolute. It is only in restricted situations where absolutely required that the authorities may act in a proportionate manner against posts on social media that bear a real issue of incitement, public disorder, or protection. Case. On September 11, 4 individuals were arrested for making allegedly offensive posts regarding racial and religious issues on social media. The police have also initiated investigations under the Sedition Act 1948 into a case where the King and Queen were allegedly insulted on Twitter by several individuals, including Parti Socialist Malaysia activist Khalid Ismail, who was arrested. Article 10 of Federal Constitution. Such arrests constitute a significant assault on our freedom of expression, guaranteed under Article 10 of the Federal Constitution. This fundamental right has a high threshold that also includes the freedom to speak in Malaysia about sensitive matters. Although certain social media posts can be distasteful or deemed offensive, it seems that some believe there should be no abuse of the law to ban such acts of speech as they do not cause any actual harm usually prohibited by criminal law. Section 233 of the Communications and Multimedia Act. A further concern is that there is no clear definition of our existing laws and limits on free expressions. Section 233 of the Communications and Multimedia Act is too vague, and any person making an offensive social media post is a possible criminal under this Act. The Aegis Chambers and the Malaysian Communications and Multimedia Commissions will issue clear, consistent and fair guidelines on what constitutes offensive online remarks. Without such guidelines, people are unable to control their own conduct to ensure that they do not cross the threshold of potential criminal offences in act.
After all, this section deals with an offensive content published electronically and enable the victim to take legal actions against the offenders as well as giving a fair punishment. It is very important to be careful before publishing a statement to ensure that we publish the correct facts instead of rumors about others.